So as a result of the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruin, a new lawsuit is currently moving which seeks to remove a state's ban on the purchase and possession of suppressors. So let's talk about this. But real quick before we jump into this video, if you think the NFA and GCA need to be repealed, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has absolutely amazing coffee, and they are huge Second Amendment supporters. They have dedicated roasts that donate to GOA and FPC, so I always recommend you check that out. I will leave a link to Blackout Coffee down below in the details section and in the pinned comment section. And if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we'll be discussing a case in the state of Illinois which seeks to remove the state's ban on the purchase and possession of suppressors. The case we're going to be discussing in this video is called Morse v. Raoul. This is a lawsuit filed in the Southern District of Illinois, and it aims to remove the state of Illinois' ban on the purchase and possession of suppressors. This case is very important because although there are 42 jurisdictions within the US that permit the ownership and possession and use of suppressors, there are 8 states, 9 jurisdictions which actually do not permit that. Those areas include California, Delaware, the District of Columbia, Hawaii, Illinois, Massachusetts, New York, New Jersey, and Rhode Island. This lawsuit uses the Supreme Court's recent ruling in New York State Rifle and Pistol Association versus Bruin to attack a state ban on the purchase and possession and ownership of suppressors. In Bruin, the Supreme Court issued a 6-3 opinion authored by Justice Thomas, which ultimately struck down the state of New York's May issue CCW licensing scheme. And ultimately, what the court found is that the state's concealed carry permit scheme was not consistent with our nation's history and tradition. One of the primary findings of the Bruin decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. In that opinion, Justice Thomas stated that despite the popularity of this 2-step approach, it is one step too many. Step 1 of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support applying means and scrutiny in the Second Amendment context. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Then, to justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if a firearms regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So that is the analysis set forth by the Supreme Court in Bruin. Now, under that Bruin framework, the state of Illinois and other states that ban the purchase and possession of suppressors must justify their bans using relevant history and tradition of the Second Amendment dating back to 1791. This lawsuit aims to finally make a state explain how their outright ban on the purchase and possession of suppressors is in fact consistent with the text of the Second Amendment. Now let's look at some of the arguments that are presented by the plaintiffs in the Morse case. First, the plaintiffs state that the Second Amendment guarantees individuals a fundamental right to keep and carry arms for self-defense and defense of others in the event of a violent confrontation. They go on to clarify that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. That is actually very important because it's well established now in the legal world that modern arms are in fact protected under the text of the Second Amendment. It's not just muskets and firearms that existed at the founding that are protected. They then go on to state that the only way that the state can regulate these types of arms is if they are potentially maybe dangerous and unusual. However, a suppressor is not dangerous and unusual, and the mere ownership of a suppressor cannot constitute the ownership of a dangerous and unusual item. And therefore, under Heller and Bruin, a state cannot completely ban the keeping and bearing of suppressors, which is a common arm owned and possessed by law-abiding people for self-defense purposes, which is a lawful purpose. This first section is the plaintiff's essentially qualifying that suppressors are in fact arms protected by the text of the Second Amendment. And since they are arms protected by the text of the Second Amendment, the state of Illinois then bears the burden to justify their ban using the text and history, essentially dating back to 1791. Even more important really is the fact that even before Bruen under Heller, this type of categorical ban, this type of outright ban on a specific type of arm that's in common use for lawful purposes would be invalid. So even under Heller, before Bruen, this ban should not have been upheld. But now even under Bruen, we have additional support to attack this type of law. Illinois is completely banning the use and possession of a protected arm. And also keep in mind that these are items that under federal law are legal to purchase and possess. This is a state level law that is going beyond what the federal law actually says. And the argument in this lawsuit is that there is no historical basis to support an outright ban by a state on these types of items. Now, the judge assigned to this specific case is Judge David W. Duggan, who is a Trump-appointed judge. Now, you may also recall in recent videos, I talked about another case in the state of Illinois, which was also attacking the state suppressor ban, and that was the Anderson v. Raul case. Recently, in the Anderson case, the judge in that specific case held that the lawsuit needed to be put on hold for at least 90 days because that judge believed that the suppressor lawsuit, which he was dealing with there in the Anderson case, may in fact be impacted by other lawsuits which are currently challenging the state of Illinois' ban on so-called assault weapons. Therefore, the court there in the Anderson case held the lawsuit, the challenge to suppressors and that suppressor ban, he put it on hold for at least 90 days until the preliminary injunction and the request there in the assault weapons lawsuits was in fact resolved. So that specific challenge was put on hold. The judge in the Anderson suppressor lawsuit seemed to believe that the ban potentially on flash hiders, if found unconstitutional in the assault weapons lawsuits, would maybe impact the state suppressor ban as well. That could, of course, be something very interesting, and it could have very important legal implications because a court could potentially draw a distinction or maybe even a connection between flash hiders and then also suppressors. If the Anderson court is signaling that flash hiders and suppressors are similar items to the point where one lawsuit could potentially affect a different one, that means that there could be some really interesting Second Amendment decisions coming very soon because there is maybe some sort of connection between the two. Now, really, this could also be simply the judge trying to stall the case, not wanting to deal with this issue, but it's also interesting that he's saying in some way the assault weapons lawsuit is going to impact the suppressor lawsuit. These decisions could also have nationwide impact since a complete ban on suppressors could also be struck down, could never be permitted. That then would also open the door to bring other challenges like state level challenges, like in the state of California, where they also have a state level ban on NFA items and specifically also on suppressors. But the good thing is that although the Anderson case is currently stalled right now, is on hold for 90 days, there is this other lawsuit, which is the Morse lawsuit, which is still going and is also in front of a very interesting judge who potentially is a favorable judge because he was appointed by Donald Trump. These type of lawsuits could be a step in the right direction. We're seeing some interesting lawsuits now pop up like these ones, which are using the Bruen decision to attack these state level bans. Like I said, these should have been unconstitutional even under Heller, but now under Bruen, we're seeing renewed challenges to these outright bans on items like suppressors. So this is a case we'll definitely be keeping our eyes on, and if I get any more information, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.